All right, all right. The answerers of the questions are sitting at the table, so we can go ahead with the questions and answer session. And can I say that we've overrun time a little, and this will be slightly truncated. It'll be for a 20-minute session rather than a 30-minute session. And that being the case, I would ask the questioners to be as precise as they possibly can be. So the microphones are in the room. Any hands up?
How are we doing? Dave, table 12.
Yes.
A question for John O'Dowd. In the Roach v. Roach, the explicit question regarding the life of the unborn was decided on the basis that the fertilisation was occurring outside of the womb, so therefore it didn't come under the category of the unborn. If a similar situation was to occur in the courts where it was a natural implantation, would that redefine the definition of the unborn potentially under Article 43.3 in the sense that it could, instead of actually being implantation, it could be argued that it would go back, as you said in the diagram, to an earlier stage of conception?
Well, that question, is this on? That question's left open really by Roach v. Roach, but it should be stressed that a number of the judges in Roach v. Roach did express quite a clear opinion about that. And I think it's quite clear when you read their judgments in context that they did mean that the unborn only comes into existence when implantation takes place in the context of natural gestation as well as artificial reproduction. But as I was stressing, even if that's what they thought, even if that's what their opinion was, it wasn't part of the decision because that wasn't actually what they had to decide in Roach v. Roach. So that part of the decision isn't binding. What you could say is it gives a fairly good indication of what judges would be likely to decide if they agreed with those judges, if you see what I mean. There are lots of other areas in recent years in relation to assisted suicide or the question of who's the mother in a situation of surrogacy, where the courts have said, look, we're not going to determine that question because it's not really a legal question, it's a political matter. So that might colour, how the court would approach it as well.
Very good, thank you. Any?
Hi, I'm a member of the table here on table 13. And my question's for Emily. Emily, I just wanted to check, is there evidence or I suppose scope for Article 40.3.3 to be used during labour when you can't really go into a courtroom with a woman to perform interventions such as maybe a sweep, an ARM, an episiotomy without consent, and almost for midwives and doctors to operate on the principle of forgiveness, regardless of whether or not an unborn's life is at immediate risk?
Yes. Do you understand the question?
Fully understand the question.
Yeah, I know. Well, perhaps just outline your understanding of it, just so we're not at cross purposes. That's what I'm concerned about.
I think what you're asking is whether or not Article 40.3.3 could grant a licence to perform certain procedures during labour, even where the fetus's the fetus's life is not at risk.
Yes, but also, I suppose, to allow them a principle of forgiveness to use these, is there scope for abuse of it in the delivery room?
Well, I think vis-a-vis the first part of the question, will Article 40.3.3 be used to licence treatments without consent where the life of the fetus is not endangered? I think the answer to that is no. Vis-a-vis the second question of whether or not procedures which are necessary might be forgiven, and by that I take it you mean forgiven in the sense of not viewed as either negligent or without consent or a breach of the mother's right to bodily integrity and autonomy.
If I may just interrupt you just for 1 minute, I'm more talking about maybe a case taken towards the NMBI or the Medical Council where a doctor has performed a sweep without a woman's consent, or a midwife has broken a woman's membranes without her consent. If she has explicitly said, I do not consent to this, will they be likely to face penalties? or will they be likely to be forgiven because the Eighth Amendment leaves it vague as to where they need to intervene? It's quite difficult to explain. I'm sorry, I'm not doing it justice.
I don't think the Eighth Amendment affects that situation, would be my answer.
Yeah. I mean, I think you're straying into medical negligence territory, which is a totally different terrain. Yeah.
Thank you.
Thank you.
Thank you, Judge.
Yes,
I'm the facilitator for Table 3. The citizens at this table had two questions. The first, indeed, Judge, you may need to add some comments to this, is when a case is been brought to the courts under 40.3.3, how are the judges selected? And a second question, or more of a comment, does the panel have any sense of how frequently we get a situation where the medical condition of the mother raises questions of whether she accepts or rejects medical treatment, which in turn has an impact on the fetus? Thank you.
Well, I'll deal with the first aspect of it, how judges are selected. It's not a question of selection at all. It's a question that you're, say in the High Court, you're assigned to a particular list. I used to do the Chancery list in the High Court, and it depends on the nature of the application. It could be an application for an injunction, in which case it would come to me. It could be an application for judicial review, in which case it would go to the judge dealing with the judicial review list. It's just happenstance, really, and perhaps the judge dealing with the list will not be in a position to deal with it, and he'll assign it to one of the other judges dealing with the list. So there's nothing of significance about the choice of judge who deals with those sort of applications. It depends on the nature of the application and who is dealing with the list on that particular day.
If I may just intervene. There is a difference here between the Irish situation and the one in England, because in England they have a court of protection, of course, so they have a very specialised judicial function there where judges deal. They have a much larger volume of cases. So in cases where you're dealing with the interests of the unborn or the interests of people with capacity issues, there's actually a dedicated kind of judicial core there. So maybe that colours some of the decisions they make in London because they have greater expertise and experience in the area.
And I'll just make one other point. There was mention, John mentioned, or Emily, or both perhaps, the PP case. That was perceived as a very, very important case that needed to be dealt with urgently. And in fact, it was heard, I think, on St. Stephen's Day. And it was a divisional court. It was a 3-judge court. Mr. Justice Kearns, who was the president of the court at the time, and Miss Justice Baker and Miss Justice Costello. But sometimes, if the issue is very, very important in the High Court, there is a divisional court, and it's dealt with urgently. But as I say, they dealt with that case on Christmas Day or St. Stephen's Day. It's probably St. Stephen's Day, actually. But there's nothing peculiar whatsoever about the way a particular case ends up with a particular judge. If that's the implication of the question, I don't know. And what's the second question? I've forgotten.
It was the extent to which situations arise where the mother's, where the health of the mother and her decision to either accept or reject medical treatment impacts on the fetus.
I suspect that's maybe a practical question in the sense of how often does this occur, and without trying not to answer your question, I think to an extent really that's a matter for the medical profession. I suspect it occurs in fact much more often than we lawyers are aware, but that in many cases it's capable of being discussed, considered and resolved. Certainly insofar as how often it comes to court, it is vanishingly rare.
Anybody else?
Hi, I am a citizen on table 10, and we all have this question here. It's either for Emily or John, or both. Has a father any rights in relation to the life of the unborn here in Ireland?
Well, the cases we've had so far have been, as I was trying to stress, were about fathers trying to take advantage of the right to life of the unborn, where the mother, was quite happy to continue with the pregnancy, and so there was a child going to be born in the normal course of events, and he was just making a case that it was irrational to ignore the fact that he was going to become a father in short order. We don't have any case law on whether fathers have any kind of veto over a termination taking place. When the 13th Amendment was introduced, the 13th Amendment says nothing in this subsection shall limit freedom to travel between the state and someplace outside the state. A number of people, like the Labour Lawyers Group, said this is actually deficient because it's just saying that the right to life of the unborn doesn't prevent the woman having freedom to travel outside the state. What about the right of her husband, in particular, if he's the prospective father of a child? And I think the argument there was, if you're saying that the right to life of the unborn doesn't outweigh her freedom to travel, how on earth could her husband's right to be a father surely the right to life of the unborn must be more important, if you think it exists, than the father's rights. So if you're saying that the unborn's rights don't prevent her from exercising her freedom to go outside the state, how on earth could you then uphold the putative father's right to veto the adoption? So I think in that context, that's probably the right interpretation of the 13th Amendment. So that casts a lot of doubt as to whether fathers have a right themselves. Now, as I think Emily pointed out, fathers could go to court and say, I have a special interest in upholding the right to life of the unborn because I have a special connection. And one of the tables asked me this question by way of clarification as to who's entitled to bring these cases. In the 1980s and 1990s, the Society for Protection of Unborn Children Ireland Limited were allowed to bring cases about abortion information, for instance, where they were saying that abortion clinics, students' unions, etc., shouldn't distribute information that would assist women to get terminations of pregnancy in England or elsewhere. And they were recognized as having standing to do that because it was said they had a bona fide interest and concern in the right to life of the unborn. They had a track record, they had an expertise, they were appropriate people to bring that action. But I'm not sure that would be the case if they tried to intervene in a case about a woman's medical treatment, for instance, and said, we are representing the unborn. So what the courts do typically is they appoint counsel to argue, the interests of the unborn. They don't let a particular party come in and assert the interests of the unborn. So a father might try to, become a party to such a case or bring such a case, but I think the courts might, and the father might be in a stronger position to make that case where it was about the treatment of a particular woman than some interest group would be. But I don't know if Emily has any comment.
I think maybe just to come in there as well, I don't think that there's an argument that the father of an unborn baby has any rights under Article 40.3.3. I don't think there is any argument that he does. The family law rights, the family rights might be relevant, but I would have thought that even if there is a family right in the father vis-a-vis this situation, it would be subordinated to the right to life or health of the mother, the right to bodily integrity of the mother, privacy, self-determination and so on, in a circumstance where one is considering a father's veto on an abortion. And then obviously if one were considering the fairly unthinkable scenario of a father trying to make sure an abortion did happen, clearly any rights that the father would have in that regard would be subordinated to the right to life of the fetus. So I hope that answers your question.
I mean, one thing one might add is that in Roach v. Roach, of course, the Supreme Court drew a very sharp distinction between the father there and the kind of father you were talking about, because they laid some stress on the fact that the father in that case was entitled to say, no, I don't want to become the father. I'm not giving my consent to the implantation of these frozen embryos. So that might be part of the significance of the distinction they were drawing, that he retained his right to, as one of the genetic parents, to have a veto and prevent the woman from having the embryos implanted.
I'll take one more question.
Hello, I'm the facilitator for Table 7, and a member at the table has requested the following question. If life ceases to exist when a person is deemed to be brain dead, does life begin when the brain starts to function, and at what stage of the embryo's development does this happen?
Well, as I was saying earlier on, the unborn isn't defined in Article 40, Section 3, subsection 3. And in Roach v. Roach, the judges do say that the unborn comes into existence, unborn human life comes into existence at the point of implantation, at the earliest, which is all they had to decide, really, on the most expansive view of what the issue in the case was. I think given the overall purpose of the Eighth Amendment, it's unlikely that they would find any later point and define that as when the unborn comes into existence, because the purpose of the Eighth Amendment was, however you think it should be specifically interpreted, the overall purpose of it was clearly to say this is a human life, which is to be protected regardless of whether it's distinct, in some way from the mother's organism, or it has some independence, or certainly not whether it's viable or not. So I suppose you could say, yes, the idea of a brainstem, kind of emerging, the first signs of potential consciousness might be a dividing line, but I think it's unlikely. Again, as I've said, in a lot of cases in recent years on assisted suicide, on the question of who's the mother in the case of surrogacy, in relation to marriage equality before we had the amendment, the courts have said, look, these are not issues. We don't have any way of deciding this issue for you. It's a political question. So they throw it back to the Oireachtas and to the people in this case, and they say, don't expect us to draw a line for you as to what's permissible or not. So I think that means that in this case, they would probably just say, it is implantation, and we don't really have any basis for defining some point after that. To define it as implantation is to have like a clear criterion as to when it occurs, and if people are dissatisfied with that, then they need to amend the constitutional provision.
Do you want to add anything, Emily? Very good. Well, we'll stop at this point. I think what the members of the Assembly have learned from this morning is what a lack of clarity there is in the law in relation to the issues we've been dealing with. But I'm very, very grateful to both Emily and John for their presentation, which were very engaging, and also for their papers, which once again I would urge you to read and read carefully so that you get an overview. And really, I don't know that you can get much more than an overview of the issues. So thank you very, very much. Quick cup of coffee because we're starting again at 12.